Good morning to all. I'm Chief Justice Tom Parker, and on behalf of the Supreme Court of Alabama, I thank you for being here this morning for this special oral argument session. For the law students here, we especially thank you for attending, and we hope that you will find these arguments educational, of course, but also inspiring, because we anticipate that some of you in the future will be arguing before the Supreme Court in Montgomery, and some of you may even be behind the bench. So we thank you for being here, and as I look up, I see attorneys here also, and thank you guys for being here as well. These traveling oral arguments do not simply happen on their own accord, however, and I want to briefly thank the many who have worked hard to put this program together here, and then I'll introduce the members of our court. For graciously planning and hosting our court visit today, and for the wonderful reception last night, we wish to thank the University of Alabama School of Law, Dean Mark Brandon. Thank you for all your leadership and for hosting and welcoming all of us here today. Martha Griffith and Candace Robbins and their staff, and the University Police Chief John Hooks and Lieutenant Richie Champion, we thank you for all of your diplomatic and diligent planning and work to prepare the court for our staff so thoroughly for today's event. Now let me introduce my fellow justices on the Alabama Supreme Court, and we'll do this in the order of seniority. So to my right is Justice Greg Shaw of Montgomery. To my left is Justice Kelly Wise of Prattville. To Justice Shaw's right is Justice Tommy Bryan of Brantley. To Justice Wise's left is Justice Will Sellers of Montgomery. To Justice Bryan's right is Justice Brad Mendham of Dothan. To Justice Sellers' left is Justice Sarah Stewart of Mobile. To Justice Bryan's right is Justice Jay Mitchell of Homewood. To Justice Stewart's left is Justice Greg Cook of Vestavia Hills. And as I mentioned earlier, I'm Chief Justice Tom Parker of Montgomery. I'm also glad to recognize the clerk of our court, Megan Rodebeck, and Chelsea McLaurin, who is in her office. We thank them for their service to the court and to the public. And additionally, I want to thank our IT team that came with us to make sure that all of this would work, and that's Preston Lane and Robbie Headley. Last but not least, we want to thank the dedicated marshal of our appellate courts, Earl Marsh Jr., and his team, which is today is Chief Deputy Marshal Chris Martin and Deputy Marshal John Sutherland. We thank them for all their hard work protecting and serving our court day by day. And so, Madam Clerk, if you would please call the docket.
In case number SC 2022-0719, Springhill Hospitals, Incorporated, doing business as Springhill Memorial Hospital, versus Patricia Bilbrey-West as administratrix and personal representative of the estate of John Dewey West, Jr., deceased. Arguing for the appellant, the Honorable Matthew Lemke. And for the appellee, the Honorable David Wordis.
Mr. Lemke, please.
Mr. Chief Justice, and may it please the court. In enacting the Medical Liability Act, the legislature recognized the threat that large verdicts in medical liability cases pose to accessibility and affordability of health care for all citizens of Alabama. How do we know that? Because the legislature told us in 65540 that's what they were doing. In fact, if you look at slide 1 in the materials that were submitted, the legislature said it found and declared that the increasing threat of legal actions for alleged medical injury causes and contributes to an increase in healthcare costs and places a heavy burden upon those who can least afford such increases. So, consistent with that legislative objective, the legislature enacted a series of reforms that included two evidentiary restrictions that I want to talk about today, stoplights, if you will, that limited the kind of evidence that can come in a medical liability case. Well, the trial court ran right through those two stoplights, the first of which is contained in 65448. And that is the statute that says in order for an expert to offer testimony on the standard of care, the expert must be a similarly situated healthcare provider. And the legislature expressly defined what a similarly situated healthcare provider is. And in this case, it's 548B. The person must be licensed in that area of practice, trained and experienced in that area of practice, and must have practiced in the same discipline or school of practice within the last year. In this case, Dr. Rawfield, a doctor, came in and, over the objection of the hospital, offered standard of care testimony as to what the nursing standard of care was, notwithstanding the fact that Dr. Rawfield had never been licensed, trained or experienced, or practiced as a nurse within the preceding year. And this court repeatedly, and 3 times in the last 3 years, in Youngblood, in Knoll, and in Hannah, this court has said, consistent with its overall view of the world, we're going to apply the plain language of the statute. And the plain language here is clear. Dr. Rawfield did not satisfy that standard of care. And this court in the Mihelic case indicated when an expert is allowed to testify in violation of 65548, an appropriate remedy is ordering a new trial.
So, Mr. Lemke, if I give you that point, if I were to give you that point, there's lots of other evidence about the standard of care for the nurse here, lots of it. So how do I reverse a verdict when there's so much other evidence on the nursing standard of care?
Well, I think as we point out in our brief, Justice Cook, this wasn't just sort of random evidence that came in passing. When we put on our nursing standard of care expert, who unquestionably met the requirements of 65548, the plaintiff cross-examined her by saying, did you know that Dr. Rawfield testified that a nurse should have questioned a 4 milligram dose of Dilaudid? And so what they did is they put in this improper evidence and then used it to cross-examine a nurse with what the doctor said.
Again, let me give you that. Do you have a case where we reversed when there was other evidence on the standard of care?
I don't think this court has ever addressed that particular circumstance, but I have 2 responses. One is I am unaware of any case in recent history where there was a 65548 violation found by this court. In fact, I don't think there's ever been a case where there was a 65548 violation found by this court where there wasn't either a new trial or JML ordered. So there's no history of this court categorizing it as harmless error. And I don't think it is. And as we point out in our brief, this was one of the critical points in the case, that the nurse should have questioned the doctor's 4 milligram dose. And to have the doctor come in and say that's what the nurse would have done, that was highly prejudicial.
Your own witnesses said that. So I
don't know that our own nurses said just that about the 4 milligrams of Dilaudid should have been questioned. But the key is they allowed the focal point to be this Dr. Rawfield testimony, which was totally improper. And think of the moral hazard you create if you allow this loophole to say, well, if you put on evidence from other witnesses who meet the standard of care requirements of 65548, even if they're minimally qualified, then you can bring in someone you tout as the world's leading expert, and they can come in even though they're not qualified. That sort of incentive is just what the legislature was trying to avoid. The legislature was trying to ratchet down very tightly on who can offer standard of care expert testimony in Alabama, and Dr. Rawfield could not do it. That is one basis for a new trial. Now, a separate section, another stoplight that the trial court ran through in this case arises out of Section 6.
Before you go further,
Yes, sir.
Didn't you concede that he was an expert in IV opioid hospital patient safety?
Yes, but that's not the nursing standard of care. I mean, he offered lots of testimony, Justice Bryan, on general opioid safety. And I think what we said, Mr. Lee was the lawyer who was representing the hospital, and he said, well, I'm not sure what that is, but he's qualified to testify to opioid safety. But the minute he crossed the line and started in on the nursing standard of care, we objected and said he is not qualified to get into nursing. So he was perfectly appropriate for him to testify as to what the hospital policies should have been.
The nurse was part of the patient safety protocols, wasn't she?
Well, Justice Bryan, I think this court has been very clear to carefully delineate exactly what the testimony is being offered. And on that point, this went to the nursing standard of care, not hospital policies, but whether any nurse on an orthopedic floor should question a dose of Dilaudid from a doctor. And the answer is that is nursing standard of care testimony, and the legislature has said you must meet 1, 2, and 3 in 65548 to offer it. And so we think that's apples and oranges to try to take what he's qualified to testify to and then allow him to go over the line into something he's not qualified to testify to. Now, the point I want to make about Section 6...
Mr. Lemke, and
Yes, sir.
my review of the record, numerous nurses, some called by the defense, some by the plaintiff, and even the nurse at issue in this case talked about they don't blindly follow doctor's orders and that they can question. But I do want to shift you to the damages, the $10 million under the Hammond Green Oil that the trial court bumped it down to 10. If my recollection is correct, the defense team at trial argued for $2 million. Is that what you're asking us to do under that analysis?
Well, I think the defense team at trial argued for a defense verdict.
Right, but beyond that, getting to...
And in the post-judgment motion, we said that the maximum that the court should affirm would be $2 million. But I think the first question the court has to answer on the damages goes to another section of the Medical Liability Act, and that's the cap in 65547. Because the legislature in 1987 imposed a $1 million cap on wrongful death medical liability damages with an inflation adjustment built into the statute. So today, it's over $2.5 million. Well, the legislature, or this court, in a very different jurisprudential era, in 1995, I believe it was, in Smith versus Schulte, said that cap violated the right to equal protection under the Alabama Constitution and the right to trial by jury under the Alabama Constitution. Well, subsequent to that, this court has eroded both of those constitutional foundations. A majority of the court, not in one opinion, but in multiple opinions in ex parte Apicella, said this right to trial by jury grounding in Smith versus Schulte is not correct. And in ex parte Maloff, again, a total of 6 justices, I think, rejected the basis that if you squint really hard and look at sections 1, 6, and 22 of the Declaration of Rights of the Alabama Constitution, you can see a generally applicable equal protection clause.
And I follow up just in the interest of time as well, and I certainly understand and appreciate that argument and the flaw in the equal protection argument that the court has made, and I think the court has admitted that so much. But in 6-1121, which came after the unconstitutionality of the statutory cap for med-mal, the legislature passed another punitive damages statute, but it specifically excludes caps for wrongful death. So how the interplay of that occurring?
Yes. Well, if you'll look at slide 21 in what we submitted, this court in the Benson case in 1995, the line of authority dates back to 1909, in another City of Birmingham case, the argument there would be 61121 implicitly repealed 65547. But what Benson said is implied repeal is a disfavored doctrine and will be found only when the two statutes are so repugnant to or in such conflict with one another that it is obvious that the legislature intended to repeal the first statute. In 61121J, the legislature expressly accepted wrongful death cases from this new punitive damages structure. And so there's no way you can say that there is no possible way the two statutes cannot be reconciled, and thus there can't possibly be an implied repeal. And so with the constitutional underpinnings gone and no possibility under binding law of implicit repeal, it is incumbent upon this court to fix the constitutional error that was made 28 years ago. And the plaintiff has said, well, the legislature hasn't taken action. But the Marsh case from this court says when there's a constitutional error by the Supreme Court, you can't expect the legislature to fix it. As we all learn in law school, it's emphatically the province of the judiciary to say what the law is. And this court erroneously said it's unconstitutional to have a cap on wrongful death medical liability damages.
But if we do get beyond, to go back to my initial, I guess for lack of a better term, very helpful parlay with you on this point, let's assume for a moment that we get beyond all that and we get to the final Hammond Green Oil analysis that the trial court did, getting it down to 10. Do you still believe that 2 or 2.5 is the max for this case, notwithstanding the statutory?
Absolutely. In addition to the fact of the cap, we think on the first prong of the BMW versus Gore analysis, which is reprehensibility, the trial court had 3 serious mistakes in its analysis. First of all was they talked a lot about our absence of policies, but we had evidence, both at trial and then in the Hammond hearing, that other similarly situated hospitals had the same thing we had, which was if the doctor wanted to order continuous pulse oximetry, it was available, but it had to be ordered. And that the policies we had on training and in other points were the same. What did the trial court say about that? Well, he said nothing, and that significantly impacts the finding of high reprehensibility. If you're following the industry standard, it's very difficult to say what you're doing is highly reprehensible. Secondly, not once but twice in that post-judgment order, the trial court justified a finding of high reprehensibility and thus a $10 million punitive award because Nurse Ellenwaugh lied in her deposition about giving the dilaudid. Well, the problem is when Nurse Ellenwaugh gave that deposition, she was not our employee anymore. So vicarious liability cannot apply, let alone it was outside the line and scope of employment. She wasn't even our employee. And so he justified this $10 million award in part on the former employee lying. That's not appropriate. And then thirdly, this court in Lance said, you have to consider in deciding on the reprehensibility of one actor who was part of the overall situation, you have to look at everyone who was involved. And here, the trial court ignored the fact that, two of the big things here were the 4 milligram dose of dilaudid. Well, if you'll look at slide 26, which is the prescription, Dr. McAndrew ordered 4 milligrams IV every 3 hours of dilaudid. He ordered 4 milligrams, and that's what Nurse Ellenwaugh delivered. So when you're talking about who is highly reprehensible here with regard to the dosing, Dr. McAndrew was the one who ordered it, and the nurse carried it out. And as we note in another part of our briefing, this court in Larimore said when it comes to tort liability, you can't hold anyone other than the physician liable in tort for a dosing decision. So the trial court made...
I'm sorry to interrupt you. We're running out of time, so I wanted to bring this particular issue up because it relates to what you're talking about. So we've got this case, the Bednarski case.
Yes.
Okay. Tell me why you're better or worse than Bednarski.
Well, every case comes up on its own facts, Justice Cook. As I read Bednarski, the court was driven heavily by the fact that there was an illicit profit motive that the trial court found as motivating the decision. And here even the trial court admitted there was no suggestion that we had profited from this. In addition, there was no suggestion in Bednarski that what the practice there was doing was consistent with what other hospitals in the industry were doing. And as I was saying, not only was Dr. McAndrew the one who prescribed it, the hospital had available, if Dr. McAndrew had ordered it, the continuous pulse oximetry. May I finish that sentence? He had, that was available. And so he could have ordered it. Dr. Spires, their witness, said he always ordered it. And so in the relative scheme of things, the hospital was not the most highly reprehensible actor on the scene.
Thank you, Mr. Lemke. Mr. Wirtz?
Thank you, Chief Justice Parker and Associate Justices. We've already had a trial. The trial was decided on February 22nd last year. The conflicts in the evidence were decided by a jury, and it is not this court's role to be re-examining these conflicts in the evidence that Mr. Lemke is talking about here today. And I was also reminded during his comments about the admonition from this court in Hammond v. City of Gadsden that the trial judge is better positioned to weigh conflicts in the evidence, to comment upon what happened at trial, and to inform this court of what the ultimate just result should be. Mr. Lemke wasn't there for the pretrial hearings, the hours and hours and hours of pretrial hearings on motions to exclude witnesses, motions in limine, and understand this point from Judge Pipes at the beginning of the February 4th hearing on all the pretrial motions. This is dispositive of all the evidentiary issues they've raised. Judge Pipes said, quote, and this is across the board on these motions to exclude experts and or the motions in limine. Keep in mind, these are pretrial motions, and we're all guessing at what may or may not be said, that kind of thing. This completely leaves the door open for objections at trial if either party feels like we're going into issues that either a witness is not qualified to give an opinion on, relevancy, all that kind of thing. So what happened with respect to Dr. Rothfield? Dr. Rothfield testifies at R700 through just before R900. He's qualified at 701 to 720. At 721, Mr. Lee concedes he's qualified as a hospital opioid patient safety expert. So he goes on to give his testimony. And then my partner, Mr. Duncan, asks him a question. Assuming Spring Hill had complied with the requirements of the standard of care and put the policies and procedures in place as advocated by the Joint Commission and all the standard of review literature. Now bear in mind, we had 380 demonstrative aids that went to the jury, 88 exhibits that were admitted, a mountain of nursing literature, hospital literature, standard of care literature. And so the question to Dr. Rothfield was, if the hospital had done what it should have done, what would you expect a pharmacist to do? And Mr. Lee objected, and the objection was overruled. And then Dr. Rothfield was asked, what would you expect a nurse to do if the hospital had done what it was supposed to do? The objection was overruled. Then Dr. Rothfield testifies, I would expect a nurse to recognize that 4 milligrams of Dilaudid is an enormous dose that would never be appropriate, and it was confusing. And I would expect a nurse in that situation to call the doctor and say, hey, Dr. McAndrew, this is Nurse Ellenwaugh. I've got Mr. West here, and he's complaining of pain. I'm looking at your order. You don't really want to give him 4 milligrams every 3 hours, do you? But that didn't happen either. No objection. This testimony is coming in without objection. No request for a continuing objection. So the testimony continues. And not only did Nurse Ellenwaugh give this huge dose of Dilaudid, she gave another dose over an hour earlier than the doctor had even prescribed it. So to me, it was really, this is the most egregious overdose of Dilaudid I've ever seen in my career. I can't imagine how this could happen in a hospital. No motion to strike, no objection, nothing. And so we go on for another 150 pages of testimony. Then, when Mr. Lee has his opportunity to cross-examine Dr. Rothfield, he asks the very question that they're complaining about today. He asks the standard of care question to Dr. Rothfield about Nurse Ellenwaugh. He asks, referring to Nurse Ellenwaugh, to give Dilaudid, the doses she had to give was 4 milligrams. He asked that question of Dr. Rothfield, and Dr. Rothfield answers, I disagree with that, and let me tell you why. A nurse's primary responsibility is to the patient and to keep the patient safe. A competent nurse would never have administered 4 milligrams of Dilaudid to the patient. A nurse can always refuse a doctor's order if she believes that it endangers a patient. No objection, no motion to strike. We get a motion to strike the next morning after Dr. Rothfield's been put on an airplane and flown back to Texas. So Health Trust versus Cantrell is dispositive. Unless you make a timely objection when the evidence is offered, there is no error preserved for review. And that's why we point out in the red brief the Rule 28A5 problems, and they permeate all the issues. This court has amended the rule to require an appellant to list the page in the record where the issue was raised and preserved, and it wasn't throughout the brief.
Can I steer you, just limited amount of time, back to some of the questions I had from Mr. Lemke on the Hammond green oil? I won't ask you your thoughts on whether the med-mal cap should be reinstituted. I suspect I know your answer.
I have an answer if you'll ask
A
me.
respectful answer on that. If we get to the Hammond green oil issue, and I understand that's always a big if, the way this case is postured.
Yes.
But are you aware that this court has ever gone through a Hammond green oil analysis on a med-mal wrongful death where we've upheld more than $10 million?
No, sir.
Okay, so do you think Bednarski is the most recent pronouncement? I think that was 6 or 7.5, 6.
The verdict was originally going to be 10. There was a $1 million pro tanto. The verdict was returned at 9.
Okay,
Lee County Circuit Judge Jake Walker remitted that to 6.5.
so 6. So Bednarski's probably
the latest.
in
gross.
We're in agreement on that. So again, I know you want to keep the 10, that's obvious, but the legal basis, let's throw it out that way in response to what the defense is.
I'll give you the evidence of reprehensibility, and then I will urge you to give deference to Judge Pipes for the same reason that I brought up initially about Hammond versus City of Gadsden. You were a circuit judge. Justice Stewart, you were a circuit judge. You know the responsibilities of circuit judges. In Bednarski, you, in a per curiam opinion, gave great deference to what Judge Walker wrote as his post-judgment order. That order was submitted by plaintiff's counsel, and he copied it word for word. I love Jake Walker. We went to Swanee together. He's a friend, but he took the plaintiff's proposed order. We submitted a proposed order in this case. Judge Pipes, despite COVID, despite Ashley Rich demanding that criminal cases go first, Judge Pipes took the time to write the 22-page order that's before you. Carefully reasoned, thoughtfully researched, grammatically correct. Judge Pipes took the time to tell you what the outcome should be, and that should be afforded the greatest deference based on what he observed in the trial. Now, the reprehensibility evidence.
And yeah, about his argument that Nurse Ellenwaugh, that they're not responsible for what it appears to be, everyone's conceding that she was untruthful in her deposition.
There's no case law. He wants to say that anybody can come up after the fact and go quit and go work for some other employer in some other state and be exonerated.
I do think that's what he's saying.
That's what he's arguing, but there's no case law and he doesn't cite any. And why would that ever be this court's policy? She committed the tort while within the line and scope of her employment with Springhill. That was admitted. The jury was charged she was an employee of Springhill without objection by Springhill. So her conduct, whatever it is Springhill's conduct. And we invited her to come to trial. They could have brought her to trial. They didn't. So the jury heard what her testimony was. Evidence of reprehensibility. For decades, this hospital disregarded the responsibilities of hospitals similarly situated in this country. And you have evidence in the record from Dr. Lou Nelson, the foremost toxicologist in the country, probably the world, who works presently at the New York University Hospital System. And Dr. Nelson said, the New York University Hospital System has doing post-surgical monitoring of patients like Mr. West for years before 2014. Same thing with the Rutgers University Hospital System. That's his testimony. Barbara Levin, our nurse expert, Massachusetts General Hospital System, throughout the state of Massachusetts, affiliated with Harvard University. They had been doing post-surgical monitoring of patients like Mr. West for years in conformance with the standard of care. Kim Arnold, who was our nursing CNO expert from Arkansas, she worked in a 123 hospital unit, and she testified as well. Every hospital in its system uses post-surgical monitoring. Dr. Rothfield, Texas Arlington, the largest Catholic hospital system in the country, testifies. Throughout the entire network, including Providence Hospital in Mobile, they do what the standard of care requires. Springhill elected not to do that. And you have admissions throughout our briefing, throughout the record in this case, and I'd urge you to look where we didn't have a word count limitation in the post-judgment briefing. You know, I've got an 8,000-page record, an 11-day trial, 27 witnesses, and I do my best to present it in the 20,000 words that I was allotted in this appeal, but I can't do everything. Please look at the post-judgment briefing, and you'll see we catalog Paul Reed, the CNO at the hospital, admitting, yeah, we knew it. We knew of the risks. We knew of the hazards. We had the time to implement.
Let me stop you for a minute and ask you the same question I asked Mr. Lemke. This is Bednarski. Tell me why you're worse or better than this case.
I think Bednarski helps us in many respects. Waiver of the objections to the closing argument. There is no good count, bad count issue. The negligent training issue, they didn't preserve that.
I'm not asking him, I'm on damages. Why is it, we affirmed before I was in the court 6.5, which would, with inflation would be over 7.
Yes.
So why, yours is 10. So why should we not say 7 if we were going to do that? Well, why are you worse or better than 7? Kind of a blunt question, but I thought our time's running out. So
Because 65410 says the damages should be in the amount the jury assesses. And that was the statute prior to the ratification of the Constitution of 1901. So it's up to the jury to determine what the damages should be. This court, as a fact finder, should not be second-guessing what the jury, properly charged under APGI 1128 in a wrongful...
Right, but I've got to do ham and green oil. That's my constitutional duty. So I'm trying to understand fact-wise why the facts were worse for the defendant or better for the defendant and Bernowski.
We cover a lot of that in the red brief. You have a disregard for decades of the requirements of standard of care by the hospital CNO. You have this abject failure by this new untrained nurse to administer the appropriate medications as prescribed by the physician. And let's take a moment if we can. Just forget about the clock. Let's talk about it. She gives 4 milligrams of Dilaudid when there's no competent evidence in this record that Jay West is suffering any pain at all. The testimony from Mrs. West, and I can go through it chapter and verse, he's a big, strapping, 6'2", 310-pound man. He cuts his thumb on the day she's retiring from the Mobile County Public School System as a librarian. And they're supposed to go out and celebrate that night. He's calling her from the car on the way to the hospital. Honey, I'm sorry, I'm messing up the celebration. No pain medication in the emergency room. When he emerges from the 20-minute surgery where Dr. McAndrew fixed his thumb tip, he's joking with the nurses about not being able to play the piano. According to Mrs. West, no pain medication, no need for pain medication. When she leaves at 8:30, he's the same old jovial self. When she calls back, 9:30, according to the hospital telephone record, no complaint of pain. And 30 minutes later, Nurse Elamog gives him 4 milligrams of Dilaudid. Now, what's that mean? Some of you may have served in the military. A combat medic, when he treats a soldier in a battlefield, sticks a morphine syringe that contains the equivalent of 1.5 milligrams of morphine. She gave 28 times that amount. And then, less than 2 hours later, gave another 28 times. It's a euthanizing dose. It would kill anybody, but she didn't know any better. And the hospital didn't have safeguards in place. That's why.
Can I follow up briefly on another issue also? The 10 million, which you conceded, is that currently pending, I suppose, at the top end in Alabama, and even as a plaintiff's attorney, a policy consideration, again, not to make the physician's arguments, but certainly a corporate type entity like a hospital or a nursing home may have such resources, but typical physicians, if we're going up around 10 plus, I'm willing to venture, even if they wanted to, couldn't purchase that much insurance.
Yes.
So if we get into a diminishing return, we're getting big verdicts for, let's say, egregious behavior, not commenting on this case, but let's say it's egregious, but it's just putting doctors out of business, clinics out of business.
Justice Mendham, it's a conundrum in the state of Alabama because of the nature of our wrongful death remedy. But what we know in this case are several facts. Springhill has superseded the judgment. It has posted a supersedious bond in the amount.
And I understand, again, corporate type entities perhaps, but if we do 10, wouldn't that apply to an emergency room physician who's self-insured or
Well, not at all.
family
because
physician? Or
in every single case, every defendant, no matter how powerful, how wealthy, or how poor, has the right to come before this court and go before the trial court post-judgment and seek the protections that Alabama law through the Hammond, Green Oil, Gore versus BMW 61123B criteria affords them. So no, it's not one size fit all. If you entered a judgment on the jury's verdict, which is my belief, what should have been done, and that's what I implored Judge Pipes to do, respect the right to trial by jury, leave the verdict intact. But if you leave this verdict intact for $10 million, what it will do is it will have an effect on other cases that won't end up before this court because there'll be downward pressure to settle them. That's the first thing it'll do. But secondly, everyone's protected by due process to come before the reviewing court and ensure they're not punished too severely. They have the right to present evidence and say, look, this is too much. I may be guilty of the conduct, but
I may be mistaken. I was on the court for Bednarski, but it seems like in Bednarski that the physician or the clinic in that case did not have sufficient assets and insurance to come close to covering the judgment. Because it seems like, and again, correct me if I'm wrong, but we received motions because the plaintiff's attorney was executing on the judgment because the physician or clinic could not post the necessary bond. And again, the law is the law. I mean, that does happen in cases, no doubt about it, but it's a policy consideration as well if we're going to get up around 10 plus.
well, we've been confronted with this before in Boudreaux. And in Boudreaux, we conducted post-judgment discovery. And there were 2 physicians, anesthesiologists involved. And we got to the very bottom of the issue of what are their assets? What are their future, what will the business do in the event the judgment is ultimately affirmed in full? And Judge Smith in Mobile County, upon consideration of those factors, remitted that $20 million wrongful death verdict to $4 million, given the limits of the available insurance in that case, which were 1, and I think they had assets of 1.5, if I remember correctly, but they were a cash basis medical practice, and they were generating $8 million a year and distributing it to each of their partners.
Again, if we're using Bednarski as our most recent example, it seems like we upheld a judgment that went well in excess of any ability.
Right, they only had $1 million in Bednarski and up to
Nobody got
6.5.
Yeah.
And my point here is, we know that Springhill had insurance with Inspirion Insurance Company. Mr. McGowan's here today observing from Inspirion Insurance Company, they had liability coverage.
Mr. Wirtis, I want to redirect you in the interest of time. A number of my colleagues have covered questions about Hammond Green Oil, some of which have been on my mind too. But I want to route you back to the argument that Mr. Lemke was making about revival of the statutory damages cap. I've got a couple of questions for you there.
Yes, sir.
First of all, in your view, was Schulte correctly decided?
Yes, sir, absolutely.
And why?
That was one of my cases.
I know it was. And
Yes.
Because Mr. Lemke points to the fact that he thinks that the two constitutional underpinnings of that decision have been eroded, and I wanted to give you an opportunity to respond to that.
Sure. No doubt, Meloff and Apicella contain separate writings from individual justices that amount to plurality opinions of this court questioning the equal protection footing of Schulte. No doubt, that's an historical fact. But we don't want to be the court that says, because of the racists who changed Article 1, Section 1 in the 1901 Convention, that threw out the baby with the bathwater and we no longer have equal protection in this state. You don't want to be the court to tell the black people and the brown people and the red people they don't have equal protection of the law. We have equal protection, but it's found elsewhere in our Constitution. Article 1, the way it's been rewritten, Article 1, Section 6, Section 22, Section 35, and don't forget the overarching command of the 14th Amendment of the U.S. Constitution. No state shall impose any laws that don't afford the equal protection of the laws to everyone. So we have equal protection, but it's dressed in different clothing. And even if you find there's still a fault with equal protection, Schulte was decided on right to trial by jury grounds. They don't even make a right to trial by jury argument. They just say equal protections on wobbly legs. And when you make a constitutional challenge like that, you go back to what we had to do in Schulte. We had to present evidence to show there was no rational relationship. There's no proffer of evidence to suggest today that there is a rational relationship. So what would be the predicate for any finding that they're right, other than lawyer talk?
Mr. Wirtz, your time has expired, and I think you've wrapped up that question, so thank you.
Thank you.
Mr. Lemke?
Justice Mitchell, just to set the record straight, if you look in our blue brief and in our reply brief, we certainly raise the right to trial by jury issue and talk about how ex parte Apicella, if you count all the votes, not just in the plurality, rejected that. So the constitutional underpinnings for the cap are gone, and you can't make it with the implied repeal. Now, there's been a lot of discussion about the comparator verdict prong, which is the third prong of BMW versus Gore. And that's all about fair notice. And the idea is, if the defendant had thought, and this is obviously a legal fiction, but if the defendant had thought in advance of the incident in question and looked to what their punishment might be, what would they have found? And Bednarski wasn't decided until years after the 2014 incident. At the time of this incident in 2014, the highest amount that had been awarded in a wrongful death case post-Gore was Boudreaux of $4 million. And so what $10 million represents is 250% of what was then the highest. I submit there is no way anyone could fairly conclude that Springhill or anyone else in a similar circumstance could have had fair notice that 10 million was possible when in the preceding 2 decades, 4 million was the highest that had ever come about.
I don't mean to interrupt you, but the Atkins case, which was in a era, a pre-BMW era, but it was 6.5, 6.75 or so, and if you add inflation, that puts it at 13 or 14, right?
Well, as we argue and the BCA argues, there has to be fair notice of any quantum of punishment, and this court has never even hinted that inflation should be added. And if you look back over the last 2 or 3 decades, this court, in undertaking the comparator analysis, has never added inflation to anything. So I don't see how anyone looking at the law would have said, I need to add inflation. And Atkins versus Lee is a pre-BMW versus Gore case. And, you know, the BCA makes the point that, you know, the BMW verdict was $2 million prior to the Supreme Court's intervention, and then it was cut by 97.5% to $50,000. So it showed how what a substantial change was undertaken. But on the plaintiff's argument, someone in the car dealer or car manufacturer's position today would still have fair notice of $2 million. That doesn't make any sense. Now, I also want to go back on the point about Nurse Ellenwaugh. It's important to recognize that the trial court found that more punitive damages were warranted because she lied in her deposition. They say we didn't cite a case. Oh, yes, we did. Newsom says in Alabama, a party cannot be held vicariously liable if they're no longer an employee. That's pretty basic. And the trial judge created this unprecedented $10 million judgment in significant measure because Nurse Ellenwall lied when she was a former employee. Totally outside of our control, obviously outside the line and scope of her employment. So I don't think that's going to get them anywhere. And then I also want to make the point about there was evidence in the record that other hospitals were doing it exactly as we did. Massachusetts General, Harvard's teaching hospital, in order to get continuous pulse oximetry, it was there. The doctor had to order it, just like we did. Dr. Downs, who was an expert from them, offered factual testimony that most hospitals were not doing it, did not have mandatory continuous pulse oximetry for post-operative patients back in that era. And then this suggestion that I don't know where it's coming from, that Mr. West was pain-free that evening. If you look at Defendant's Exhibit 1 on the chart, his pain level was either 6 or 7 after the first dose of the medicine. So the chart shows he was being asked what his pain level was, and he was still suffering from substantial pain. So, as we began today, I think the court needs to look to avoid the unprecedented situation of finding a 65548 violation and not having a remedy for it, because that runs counter to those purposes of the Medical Liability Act that the legislature was seeking to pursue. And we cite in our brief exactly where we preserve that issue. The minute he went into nursing standard of care, we raised it and objected. Mr. Chief Justice,
Lemke,
thank you.
You have a chart in your brief, and I appreciate that. It was very helpful, but it cuts off. It doesn't have anything before Gore, and it doesn't have any inflation information on it, and it cuts off on the day of this particular accident. So to me, it would be much more informative if it was a holistic chart and it had a longer time period on it and it had inflation on it. Would you consider submitting such a thing to our court?
If the court directs us to, we'll be happy to, but I'm not.
I'd make the same offer to assuming the Chief Justice is okay with this, I would request that the other side do the same type of thing.
But again, we certainly want to emphasize the point. Spring Hill would not have had fair notice of either the inflation or anything after the incident in question, and the world changed as our brief and the BCA brief makes clear.
Mr. Lemke, thank you.
Thank you, Mr. Chief Justice.
Mr. Chief Justice, can I offer something to help Justice Cook just for 1 second? If you look at Exhibit 804 in the post-judgment proceedings, Professor McLeod prepared those tables that Your Honor is requesting.
Thank you.
Well, our thanks to counsel for both sides. This has been a very good oral argument, and this court will take this under consideration now. And with that, we are now adjourned.